Are you a parent with many children you want to file a green card application for? Pay attention to this video. I'm Bianca Jordan, founder and CEO of Brazen Legal, where I specialize in fixing complex immigration cases. I work with immigrants in all 50 states and abroad. To learn more about me and working with my law firm, visit brazenlegal.com. So, very often I will have a consultation with someone who is a parent. Usually, this is a US citizen parent, and they have multiple children living abroad. And so they want to start the consular process for them. But their concern is they don't have enough money to be able to afford to bring all of them over at the same time. Maybe they don't have the money to pay attorney's fees, immigration fees, the expenses that this process will entail. So they'll ask me if it's possible to petition for some of the children and petition for the others at a later time. And so what I usually have them consider is if you have children that you cannot petition for, if you have a lot of children and you're trying to figure out who to petition for first, you should consider prioritizing the oldest children first. And the reason for that is because the older the child is, the closer they are to the age of 21 when they will age out. And if they age out, then their process is going to take a really long time. Right now, it is taking a minimum of 7 years. So you should really consider filing that I-130 as soon as you possibly can, because not only is it better to just get the application started, but there's something called the Child Status Protection Act. And the Child Status Protection Act basically freezes the beneficiary's age at the time that the I-130 was filed. So let's say you have a 17 or 18-year-old who is the beneficiary of a green card application or an I-130. If you file that I-130 when the beneficiary is 17 years old, their age will be frozen at that time. And so what the Child Status Protection Act does is it kind of acts like some immigration math, and it has a special calculation such that even if the consular process takes so long that the beneficiary is now over the age of 21 by the time they have their interview or get their immigrant visa, the Child Status Protection Act will protect them from aging out so that they can still enter into the United States in somewhat of a timely fashion. So definitely prioritize filing for the older children versus the younger children. I have had many clients who were able to enter the United States years after turning 21 simply because that I-130 was filed with enough time to let the Child Status Protection Act do its thing. I hope you found this video helpful, and if you did, please be sure to subscribe to this channel and share this video with anyone you think would benefit. Thanks for watching.